On a recent Tuesday, the Supreme Court took center stage in a contentious debate that has rippled through the political landscape and social media. The discussion revolved around the potential overturning of obstruction charges against individuals involved in the January 6, 2021 Capitol riot. At the heart of this legal battle is the charge of obstructing an official proceeding applied to over 350 defendants, including former President Donald Trump. This charge, stemming from the 2002 Sarbanes-Oxley Act, originally enacted in response to the Enron scandal, carries a sentence of up to 20 years. Critics argue that this law, intended to combat evidence tampering, was never meant to address insurrection or obstructive acts against the democratic process. The debate intensifies as conservative justices, who form a 6-3 majority on the court, raise questions about the applicability of the anti-shredding law to the unprecedented events of January 6. Their scrutiny falls on whether the law's broad reach, which includes a clause on otherwise obstructing an official proceeding, could unjustly encompass actions beyond evidence destruction, potentially affecting peaceful protesters. This line of questioning suggests a concern for the limits of prosecutorial reach and the implications for political protests in the future. Justice Brett Kavanaugh, prominently featured in discussions both in the courtroom and on social media, questions the necessity of the obstruction charge given the multitude of other charges against defendants like Joseph Fisher, a former Pennsylvania police officer. Kavanaugh's skepticism reflects a larger debate over the justice system's approach to January 6 participants and whether existing legal interpretations suffice to address the complex blend of violence, the political protest, and attempts to disrupt the certification of election results. This legal scrutiny comes amid a backdrop of historical legal battles and scandals, notably the Enron case, which directly influenced the creation of the Sarbanes-Oxley Act. The act aimed to close a loophole that allowed the destruction of documents to avoid scrutiny in financial scandals. Now, justices grapple with whether this law's scope can legitimately extend to obstructive conduct during the Capitol riot, with implications not only for Trump's legal battles, but for how America defines and prosecutes obstruction of governmental processes. While liberal justices lean towards a broader interpretation of the statute, conservative justices and critics argue about potential overreach and the dangers of applying such a charge to a wide array of conduct that could stifle dissent and political engagement. The Supreme Court's decision, eagerly awaited by late June, promises to have profound implications for the Justice Department's capacity to hold individuals accountable for actions aimed at obstructing the peaceful transition of power, setting a precedent for how America navigates the fine line between safeguarding democracy and ensuring freedom of expression.